Today I'm here to discuss about the case BLS Infrastructure Limited versus Rajwant Singh and others. This case came before the Supreme Court of India under the criminal appellate jurisdiction, and this case was decided by the division bench of the Supreme Court by Justice Manoj Mishra and Justice Sudhanshu Dhulia. When coming to this case, a specially petition was filed by the appellant in the Supreme Court against the judgment and order of the Delhi High Court, which dismissed the appellant petition against the order of the Metropolitan Magistrate of Southeast New Delhi, where the lower court has dismissed the 8 criminal complaints filed by the appellant for non-appearance of the complainant. When coming to the basic facts of this case, is that the appellant, who is the appellant in this case, has filed 8 complaints against the respondent under Section 138 of Negotiable Instruments Act 1881, which is the check case. Of these 8 cases, 3 cases was filed in 2011, 3 cases were filed in 2013, and 2 other cases was filed in 2017. And while undergoing the trial of these cases, out of all these 8 cases, the complainant was subjected to the cross-examination in 3 cases, and after the cross-examination, the counsel for the accused made a statement before the lower court that the cross-examination of the complainant in the above 3 cases shall be adopted for the rest of the cases. The learned magistrate accepted the prayer of the accused counsel and ordered the closure of the complainant's evidence, and cases was listed for defense evidence. At this stage of this case, the complainant had filed an application under Section 311 of CRPC, which mentions about the power to summon material witnesses and examine persons for the case, for summoning certain witnesses. And while this case was going on, the appellant was misled by his counsel at the lower court that the appellant's presence is not required at the settlement, as the settlement was negotiated in the lower court. And believing what his counsel has said, the appellant has not appeared in the court, and the complaint or the cases that was pending in the court was dismissed on the ground that the complainant does not appear. That is for non-appearance in the case. And while this case was being dismissed for non-appearance, this was challenged in the Delhi High Court, and Delhi High Court also dismissed the appellant's petition. Now, coming to this case, this case was was filed challenging this order of the Delhi High Court. And in this case, the appellant's counsel argued that the magistrate in the lower court did not consider carefully the subsection 1 of Section 256 CRPC while dismissing the case. When coming to the Section 256 of CRPC, it states that if summons has been issued on the complainant and on the day appointed for the appearance of the accused or any other day subsequent thereto, which the hearing may be adjourned, if the complainant does not appear, the magistrate shall, notwithstanding anything contained, can acquit the accused unless for some reasons he thinks fit, provided that where the complainant is represented by a pleader or an officer conducting the prosecution, or where the magistrate is of the opinion that the personal attendance of the complainant is not necessary for completion of the case. And as per this section, it enables the magistrate to dispense with the case with the attendance of the complainant and proceed with the case where the complainant is represented by a pleader or an officer, or where the magistrate is of the opinion that personal appearance is not needed. Here, the counsel for the defense also stated that the order under Section 256 subclause 1 can be considered as an acquittal as this case has been dismissed for the reason of non-appearance. And after going through all these cases and all these sections and other provisions, the Supreme Court held that in this case, the court held that a plain reading of Article 256 Clause 1, Section 256 Clause 1 of CRPC can be inferred that when the magistrate is satisfied that the personal attendance of the complainant is not necessary, he can dispense the attendance of the complainant and proceed with the case. Now, if in this case such a situation has arisen, and so the For that reason, the complainant should not be dismissed from the case. And here the court has cited two cases, that is S. Anand versus Vasumati Chandrasekhar. That was a 2008 decision of Supreme Court. Here the court has considered a similar situation where the complainant was absent and but his witnesses were already examined. Here, the court in that case held that for the disposal of a complaint in default, it means that acquittal itself. But if the examination of the defense witness on the date fixed, the appellant can examine the witness if only he wants. In such cases, the appearance of complainant is not necessary. His pleader or his counsel can cross-examine the defense witnesses. Similarly, the court has also cited Associated Cement Co. Limited versus Keshavanand, that is a Supreme Court decision in 1998. Here, where the court has discussed the purpose of Section 256 CRPC. Here, the court stated that when a complaint is being filed, a law is set into motion, and if the complainant was given the complaint does not appear in the court, then it will cause a prejudice for the accused. That the accused will be appearing in the court for all the days, all the days when the case is being posted, and the complainant will not be appearing. That will cause an harassment to the accused. And this section is being provided in CRPC to afford action of protection to the accused against such tactics of the complaint. And considering all these sections of the CRPC and all these cases, the Supreme Court held that in this case, the complainant had already been examined as a witness. It would not be appropriate for the court to pass an order of acquittal merely on non-appearance of the complainant. And the order of acquittal in this case was set aside by the Supreme Court, and the court directed the prosecution would start from the stage where it reached before the order of acquittal. And in this case also, there another point that came into the consideration was the complainant has moved an application under Section 311 CRPC for summoning and examining further witnesses. While the lower court and the high court dismissed the petition, they didn't consider this application filed by the appellant. And the Supreme Court held that if the appellant has not appeared to press the matter under Section 311, then the learned magistrate should have rejected the application and should have considered the already pending case and should have proceeded with the available evidence.
In BLS Infrastructure Limited versus Rajwant Singh, the issue brought forth by the Supreme Court was whether the magistrate was justified in dismissing the criminal complaints for non-appearance of the complainant even though the statement of the complainant had been recorded, and also whether Section 256 of CRPC was clearly interpreted by the High Court and the learned magistrate in this case. The court heard both the sides of the case. The counsel for the appellant focused on the proviso of Section 256, which enables the magistrate to dispense with the attendance of the complainant and proceed with the case where the complainant is represented by a pleader or by the officer conducting the prosecution, or where the magistrate is of the opinion that the personal attendance of the complainant is not necessary. Here, as the statement of the complainant had been recorded and the complainant was also subjected to cross-examination, there existed admissible evidence on record in support of the complaint case. In these circumstances, even if the complainant was absent, the magistrate could have proceeded to decide the case on merits. Thus, the order of the magistrate stands vitiated. He relied upon three cases in support of his submissions. The first one is Associated Cement Company Limited versus Keshavanand. Second one is Anand versus Vasmati Chandrasekhar. And third one is Ramakrishna versus Rami Reddy. On the contrary, the counsel for the respondents focused on subsection 1 of Section 256 of the Code, which mandates the magistrate to acquit the accused if on the day appointed for the appearance of the accused or any day subsequent thereto, to which the hearing may be adjourned, the complainant does not appear. Owing to the rivalry in the statements, the court looked over the definition of Section 256 of CRPC. This section simply explains that where the magistrate is satisfied that the personal attendance of the complainant is not necessary, he can dispense with the attendance of the complainant and proceed with the case. And also such a situation may arise where the complainant's or the prosecution's evidence has been recorded, and to decide the case on merits, the complainant's presence is not necessary. Therefore, it was held that where the complainant had already been examined as a witness in the case, it would not be appropriate for the court to pass an order of acquittal merely on non appearance of the complainant. Thus, the order of the acquittal was set aside, and it was directed that the prosecution would proceed from the stage where it reached before the order of the acquittal was passed. The court referred to the three cases which were cited by the counsel for the appellant. And also, the Telangana High Court recently ruled that the discretion conferred upon by a court by virtue of Section 256 of CRPC should be exercised judiciously. Thank you, sir.
As already mentioned by almost all the members and very rightly mentioned by Nivea, this case and considering all is concentrated upon Chapter 20 of CRPC, which is a trial of summons case by magistrate. And so, as we know, this Section 256, which deals with non-appearance or death of a complainant, and the method that magistrate has to adopt while considering the complaint or adjourning the same is questioned. This present case, has already explained, the magistrate, the trial court had in several occasions called for the complainant, and there was no one to represent the complainant herein, and as well as any counsel for him was there. So he acquitted the the accused persons. The same was upheld by the High Court, and later now it has been filed as a special petition before the Supreme Court. Now, there are various cases which has been quoted here, of which Gino sir has rightly mentioned about Associated Cements Company case, wherein the purpose of Section 256 as a deterrent towards the delaying tactics by the complainant against the prosecution was highlighted. So, Section 256 main objective is to counter it and upholding the rights of the accused person herein because of the delay on the part of the complainant in appearing for the case. So later on, this Supreme Court has, after analysis, has pointed out that appellant has led its evidence and thereafter moved an application under Section 311 to summon and examine further witnesses. High Court as well as trial court did not take into consideration that appellant's cross-examination was only over in the three cases and not in the other ones. And also, Supreme Court held that if the complainant had not appeared to press the application under Section 311 of the Code, the learned magistrate could have rejected the application under Section 311 and proceeded with the case on the basis of available evidence. So, in the present circumstances, the proceeding are to be restored, and the learned magistrate, as well as prosecution, shall now proceed from the stage where the order of acquittal or dismissal of the complaint was passed. So, Nivea has mentioned about a Telangana High Court case wherein the judicial discretion must be examined. As she mentioned, Telangana High Court has rightly mentioned that the judicial discretion must be exercised very cautiously. Similarly, Calcutta High Court in other case has also mentioned that in a complaint filed under Section 138 of the Negotiable Instruments Act and an order of acquittal on the accused merely on the order of acquittal of the accused merely on the non-appearance of a complainant cannot be passed by the magistrate without forming a judicial opinion. That was a recent case of the Calcutta High Court. Now, in the present case also, Supreme Court has went on by considering various details and particularly that the cross-examination of the complainant herein was only done for three cases. The remaining five was clubbed together and was disposed of. That is clearly uh, a that is clearly to be vitiated. So Supreme Court found ground in that, and yes, it has done it rightly. Now I would like to invite your attention to the report of Law Commission of India, which is report number 283, which deals with which is titled Amending CRPC, Enabling Restoration of Complaint, which was drafted by Justice A.R. Lakshmanan. And inside it is mentioned that it is reiterated rather that the 141st report of the Law Commission that 256 of CRPC need to be amended for the restoration of a criminal case where the accused was acquitted for non-appearance of the complainant, where there was sufficient cause for non-appearance, and it should be in the lines of Order 9, Rule 9 of the CPC. Similarly, Supreme Court has in Major General A.S. Gauraya and another versus S.N. Thakur and another, which is AIR 1986 SC 1440, held in paragraph 9 and 10 as Section 249 of the Criminal Procedure Code enables a magistrate to discharge the accused when the complainant is absent and when the conditions laid down in the said sections are satisfied. Section 256, Clause 1 of the Criminal Procedure Code enables a magistrate to acquit the accused if the complainant does not appear. Thus, the order of dismissal of a complaint by a criminal court due to the absence of a complainant is a proper order. But the question remains whether a magistrate can restore a complaint to his file by revoking his earlier order, dismissing it for non-appearance of the complainant and proceed with it when an application is made by the complainant for reviving it. A second complaint is permissible in law if it could be brought within the limitations imposed by this court in Pramata Nath Talukdar versus Saroj Ranjan Sarkar, which is AIR 1962 SC 876. Filing of a second complaint is not the same thing as reviving a dismissed complaint after recalling the earlier order of dismissal. The Criminal Procedure Code does not contain any provision enabling the criminal court to exercise such an inherent power. So, from what I could gauge from this case and also from the recommendation of the Law Commission is that necessary amendment must be brought in force in Section 256 as warranted by the Law Commission of India to enable the magistrate by giving them inherent powers to revive the complaint if there is any justifiable cause, so that unnecessary delay and appeals such as this one, as we have seen here, need is not called forth, and proper justice to the victim is done, and also the recommendations of the another recommendation of the same Law Commission's report of 233 stresses that the 482 CRPC, in line with the 482 CRPC, the inherent powers of the High Court must also be given to the subordinate courts. That is also done. Then I believe the uh, proper administration of justice as well as the valuable cost and other thing associated with this criminal criminal justice administration will be taken care of. And yeah, that's my analysis on this case. Thank you.